Hi, this is Elody Tignor speaking, and this presentation is going to go over internet privacy regulation in the United States. This topic is particularly important today because as we are all staying indoors, there is an increasing use of the internet. In any event, internet users should be concerned with how companies use their personal information and who in the United States regulates privacy. This presentation will go over the FTC's power to regulate the internet, resources a company might use to effectively comply with privacy laws, and the possible future of private enforcement actions. So first I'm going to go over who oversees the internet. In the United States, the right to freedom of speech orients the United States' policies on privacy. In fact, there is not really an administrative agency solely dedicated to internet privacy. Instead, the United States remains largely an ex post incident response regime, regulating privacy primarily by industry and self-regulation. In other words, it's an open skies approach to privacy. For example, the Department of Health and Human Services is responsible for enforcing HIPAA, and the Consumer Financial Protection Bureau oversees the Gramm-Leach-Bliley Act. These agencies both deal with their own privacy issues in their particular industry. This policy of self-regulation was made clear in the Clinton administration's Framework for Global Electronic Commerce. From this framework, many organizations dedicated to self-regulation efforts surfaced. A few of the better-known organizations are the Online Privacy Alliance, Trustee, and the Privacy Leadership Initiative. Even though privacy is largely self-regulated, the United States Supreme Court in Katz v. United States has held that individuals have a reasonable expectation of privacy. The Federal Trade Commission adamantly disagreed with the Clinton administration's framework and responded with the publication of two reports to Congress. The first report appeared in 1998 and was titled Privacy Online. In this report, the FTC conducted a survey of over 1,400 commercial websites and concluded that effective self-regulation had not taken hold. Therefore, the FTC illustrated core principles of fair information practice that entities should focus on. These core principles revolve around consumer notice, choice, access, and security. The second report targeting the self-regulation framework was sent out in 1999, entitled Self-Regulation and Privacy Online. The FTC stated their privacy concerns, explaining that through cookies and tracking software, website owners are able to follow consumers' interests and gather information about their personal interests and preferences. Today, this data is a multi-million-dollar industry. The FTC added a core principle in this report. This was the enforcement or redress principle, which requires governmental or self-regulatory mechanisms to impose sanctions for noncompliance with fair information practices. So now we can go a little bit further into the Federal Trade Commission's role. The FTC is the primary federal privacy regulator in the United States. It uses its unfair and deceptive trade practices authority to regulate and enforce internet consumer privacy and data security. Although it has a limited role because, as previously mentioned, the U.S. deals with privacy concerns by industry, the FTC's two main goals are to protect consumers' personal information and to ensure that consumers have the confidence to take advantage of the many benefits of products offered in the marketplace. There are several ways the FTC promotes consumer privacy and data security. For instance, the FTC has brought many enforcement actions that has generally been successful. By 2019, the FTC had brought more than 130 spam and spyware cases, 80 general privacy lawsuits, and more than 70 cases involving inadequate protection of consumers' personal data. In the next section, I will talk about some of the more specific enforcement actions the FTC has brought. The FTC also promotes privacy and data security through advocacy. This includes testifying before Congress on privacy and data security issues. Recently, the FTC filed a comment on National Institute of Standards and Technology's proposed privacy framework. This comment called for greater attention to the need to address the risk of privacy. Congress has given the FTC authority to issue rules that regulate specific areas of consumer privacy and security. One example of such a rule is the COPPA rule. This rule requires websites and apps to obtain parental consent before collecting personal information from children under 13. The FTC also hosts workshops. PrivacyCon is a conference to examine research and trends in protecting consumer privacy and security. The next PrivacyCon is still set to be held this July in DC. Consumer education and business guidance are also a couple of more ways on how the FTC promotes consumer privacy and data security. In 2019, the Cybersecurity for Small Business campaign commenced. This campaign released materials covering a dozen topics, including cybersecurity basics and vendor basics. Also in 2019, the FTC created new online consumer education about mobile payment apps and updated its guidance on how to protect your phone and data on it. Later on in this presentation, I will go more into detail on the specific business guidance the FTC has issued, but it too is a big part of how the FTC promotes consumer privacy and data security. Now we can talk about the enforcement of privacy harms. As previously mentioned, the FTC is generally successful in its enforcement actions. Major popular companies have been the subject of an FTC privacy enforcement action. For example, in July 2012, the FTC brought an enforcement action against Facebook, where it was found that Facebook represented to consumers that their information would be kept private, when in fact it was repeatedly made public. The penalty for this was an unprecedented $5 billion penalty. In December 2014, Snapchat was also found guilty of misrepresenting the extent to which consumers' messages would be impermanent and deceived consumers about the amount of personal data Snapchat collected. Part of its settlement with the FTC requires Snapchat to implement a comprehensive privacy program that will be monitored by an independent privacy professional for the next 20 years. Uber Technologies has also recently settled a claim where it was found that Uber deceived consumers about employee access to their personal information. Similar to Snapchat, part of its settlement with the FTC included audits of its privacy and security systems for every 2 years for 20 years. So unlike the FTC enforcement actions, tort cases on privacy harms are generally unsuccessful. A big part of this is that there is no definition of personally identifiable information in the United States. Therefore, it's difficult to determine what constitutes a privacy harm. Other privacy laws across the world, such as the EU's GDPR, defines personal information as information that can identify you. This includes your name, phone number, home address, IP address, date of birth, social media posts, health records, race, religious opinions, and so on. In other words, personal data is any type of data that can be directly or indirectly associated with an individual. It may be time for the United States to come up with a definition of personally identifiable information. However, even if the US does this, there is still another issue, and that is that in most states, except for California, they don't allow for a private right of action in that area. And this leads me to discussing notification laws and private right of actions. So California is the only state in which individuals have a right to sue companies over privacy violations. California's Consumer Privacy Act is similar to the GDPR. This act encompasses business obligations with regard to the collection and sale of personal information. More specifically, It requires businesses to provide notice to consumers of their rights under the Act. For example, providing notice of the right to opt out of the sale of personal information. The Act also requires businesses to provide consumers a list of categories of personal information collected about them in the preceding 12 months, and whether the business sells or discloses their personal information. Other states may have similar notification laws. However, they don't offer a private right of action and deal only with financial harm and theft. There is currently a federal privacy bill in the works, and this bill would give individuals a private right of action for privacy violations. This bill has most recently stalled in the Senate in March 2020. And now we can take a look at resources a company might use to effectively prevent privacy harms. So on Bloomberg's Practical Guidance, there are examples of drafting privacy policies, presenting the privacy policy to the user, and guidance on incident and breach management. Lexis also offers companies some guidance on how to comply with privacy regulations. For example, Matthew Bender Forms and Checklists provides computer and internet law forms and computer and internet law checklists. The FTC also has 2 blogs related to privacy. The first is the FTC's consumer blog. This blog alerts readers to potential privacy and data security hazards and offers tips to help them protect their information. The second is the FTC's business blog. This blog addresses recent enforcement actions, reports, and guidance. An example of this guidance is guidance for small business cybersecurity. So finally, we should ask, should there be more rulemaking? There are privacy advocacy groups, such as the Electronic Privacy Center, that say self-regulation will not safeguard personal privacy and urge for the government legislation and regulation concerning the methods used by marketers to use information they gather from tracking internet users. Now, if there were to be more government legislation and regulation in this area, there are pros and cons. First, as a pro, there would be notice and comment rulemaking provided by the Federal Register. This is a pro because it would allow people to comment on the laws the government wants to adopt. This might provide more clarity to the privacy and data concerns users have. Now, the downside of doing this, however, is that there would be less flexibility. Less flexibility generally means that businesses will not be able to innovate as quickly. Also, small businesses may not be able to keep up with the costs of compliance, leaving only the big entities in the game. As everyone remains indoors, Americans are spending more of their time online, and internet use has soared between 50 to 70%. With this uptick in the use of sites and apps, a lot of personal data is being collected. As mentioned, personal data is a highly valuable multi-million-dollar industry. Moving forward, hopefully the FTC will be able to keep up with its enforcement actions, and we will see whether the bill on private right of actions for privacy violations will be successful.